Well, welcome to the show. I am your host, Daniel, and today is Judge Lynisse Bryant. Somebody you don't want to mess with. But let's get the show started. Share screen. Make this bigger. I have no idea why it's not maximizing it, but here we go.
I mean, well, then I don't even need to look at it. If he want to keep paying for drug tests through April, if he want to keep going to drug tests through April, then let's go. No, well, stop shaking your head and things and such then. And let's do the case. You know, I don't come on here to play games. Now, Judge Baltimore signed the order in my app. I wasn't here. He didn't have the hearing. Officer.
Hello, my name is Adam Ferrari.
who is not present today, and I did not receive an update from Ms. Bryson. However, let's see if the register is going to tell me something. So until Mr. Flanagan is going to send me the register of action, but Ms. Hall, Mr. Floyd, can you come into the screen, sir?
Oh, yeah. There. Okay, there we go.
Okay, thank you. Ms.
You're
Hall?
welcome.
Your Honor, it's my understanding that Mr. Floyd has actually completed all of the requirements imposed by this court to complete probation.
Let's see. Mr. Flanagan,
Yes, Your Honor.
did you receive a request for a probation discharge on Mr. Floyd?
No, Your Honor.
Then perhaps probation doesn't agree with the assessment that he has completed the terms and conditions of the probation. But let's try. Mr. Flanagan, I know I told you don't worry about calling Mr. Farmer back, but can you try?
Yes, ma'am.
Oh, let's see. Maybe there's something that they have that will help us. So it looks like Mr. Floyd was placed on probation by me back in April of 2023. He was ordered to complete the victim's impact panel, watch the consequences video, attend the alcohol highway safety. He was ordered to submit to urinalysis and pay $11.30. So, whoops. First of all, let's see. So he does have a zero balance according to the Register of Action. I'm having a hard time with Mr. Floyd's camera angle. I'm having a hard time with it. All right, so we're going to try to see if we can confirm that he completed the terms and conditions of the probation, so he doesn't have to come back. If he has, he would have completed over half of the probationary period. So let's see if I can get a response from Mr. Farmer. Oh, order for. I hate when I don't. Okay, try to call Mr. Schiotti. Try to call Mr. Schiotti for me and see if he can either if he can find Mr. Farmer or look for it. And then hold on a pair of seconds. Hold on 1 second.
Well, let me do the case number.
Oh, no, that's fine if they're going to do it. Thank you. Okay.
Okay.
So let's just wait a moment for the call back from Mr. Farmer. Ms. Hall, you're not ready on Boyd. Are you ready on Boyd?
Yes, Your Honor.
Oh, okay. Well, then let's switch over to Boyd. This is case number 214433001, the People versus Brian O'Neill Boyd. Defendant is charged with operating with a high BAC. Driver with open intoxicant in a motor vehicle. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakidia Hall on behalf of Brian Boyd. Sir, may you unmute yourself and state your full name for the record? You're muted.
I got it. Brian O'Neill Boyd.
You're muted, Judge.
Today is the day set for final pretrial conference. How are we proceeding?
Mr. Boyd would like to continue his not guilty plea and set this matter for a for a jury trial.
The court continues the not guilty plea on behalf of Mr. Brian Boyd, set the matter for jury trial. Mr. Flanagan, can you go to August 26th, please?
Yes, Your Honor.
Do I have any?
Nothing on that day.
All right, the court is going to set the matter for August the 26th with the final pretrial conference, August the 16th at 9:10. Anything further?
No, thank you, Your Honor.
Nothing further for Mr. Boyd.
All right then, Mr. Boyd, you're all set. Have a great day. Stay safe, and I'll see you August the 16th at 9:10 on Zoom.
Okay. Have a great day.
All right, thank you.
Bye.
All right, with respect to Mr. Floyd, Mr. Farmer is looking up the notes, so I should have an answer shortly, and we'll see if probation agrees with Mr. Floyd that he has completed the terms and conditions. So let's go on a few minute break, and I'll see if Mr. Farmer can pull up those notes, okay?
Thank you.
All right, you're welcome. All right, we're back on the record with Mr. Floyd, and I did receive something from probation. Let's see here. According to Mr. Farmer, Mr. Floyd did not do the victim's impact panel, and he has failed to test several times for the last several months. That's what Ms. Stevenson, maybe you should put your appearance on since Ms. Hall was the one doing it before.
Okay, for the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Kenneth Floyd.
All right, so Ms. Hall said that Mr. Floyd said that he had completed. Mr. Floyd, please sit up for court. Just sit up straight for court for me. That Mr. Floyd said he had completed all the terms and conditions. So I hunted down probation. His probation officer is Ms. Bryson, but she's not here today. So Mr. Farmer sent the court an update indicating that what did I just do with the update? Hold on. Indicating that Mr. Floyd still needs to complete the victim's impact panel, and he has failed to test for several months, and they say they submitted a violation to me, but I don't, when I put this in my search engine, I didn't see any violation requests submitted, but they said they submitted a violation previously. So did you all need to speak to Mr. Floyd about the fact that he is failing to test on an OWI case, and his failure to test means that he's tested positive on however many times he did not test, and that is a violation of his probation?
Yes, I would.
Go ahead.
Yes, I would like an opportunity to talk with Mr. Floyd, Your Honor, but so does the court have a violation, or?
I didn't see it when I it wasn't Google. When I searched my email, I didn't see it. Mr. Flanagan, is there a request in the file for a violation?
Yes, Your Honor, signed by Judge Baltimore.
Oh, see, it wasn't signed. I didn't know anything about it. When was he supposed to come for violation? It doesn't say it on the docket. What court date was set for the violation?
It was set for December 5th.
Oh, I still wasn't here. So what happened on December 5th?
And on December 5th, Judge Austin Garrett scheduled it for today.
Oh, it's not reflected on the docket for today. It just says review. So apparently violation was supposed to be today, but it doesn't say violation hearing today. Okay, so he can go back to the breakout room, but.
Okay, so the alleged violation is failure to test?
Mr. Flanagan, can you send it to me and Ms. Stevenson?
Yes, Your Honor.
All right.
Thank you. Yes, Your Honor.
Okay, we're back on the record with case number 1-846-09601, the People versus Kenneth Raymond Floyd. Okay, so I have had an opportunity also to look at the initial request for the probation violation signed by Judge Baltimore. And it said that the defendant had stopped submitting to, wait a minute, what's this? What is this y'all just sent me, Mr. Flanagan?
That's to counter the violation.
Okay. So the original violation indicated that Mr. Floyd had stopped submitting to urinalysis, and had failed to provide proof of the alcohol safety class and the victim's impact panel, and that he has failed to report to probation. So, Ms. Stevenson.
So just to the emails that he could put his hands on quickly, Your Honor, show that that that's not quite correct. We do have communications direct. Mr. Floyd advised me that he has been calling the probation department. He had been calling and not getting any response. And so my suggestion to him was that he stop calling and start emailing. And he did that. The court has 2 of the emails that he sent in January to Ms. Bryson as well as to Mr. Farmer. I think the court does have the email showing proof of having completed the alcohol highway safety education course. He emailed that directly, I think, to Mr. Farmer, also completing the victim's impact panel. And then even though he wasn't supposed to do this, according to Mr. Floyd, the drug testing agency told him they didn't want him sending that stuff, that they had to send it. And he's like, no, I need to get this directly to my probation officer myself because they're saying I don't do these tests. So he emailed those receipts of tests to Mr. Farmer. And I think he has some more, but just for the sake of, getting to this hearing, Mr. Floyd wants the court to know that that is part of the proof of that he has done what he knows how to do to contact the probation department by telephone, and finally by email. And he has been going to urinalysis, and he did those counseling sessions, Your Honor, and provided proof of that to the probation department.
So, Mr. Flanagan, don't send that to me. Send that to Mr. Farmer.
Okay.
I'm not going to confirm anything in those emails.
I just wanted to, I didn't want to have any ex parte communication with the court, which is why I sent it to Mr. Clerk, Your Honor.
Mm-hmm. So who was his probation officer? So all of a sudden they stopped communicating with him?
So that's part of the issue. He says that somehow he was able to find out that he should be with Mr. Farmer, possibly. And then he found out somehow that he should maybe be with Ms. Bryson. He said there's a 3rd probation officer. Okay, Mr. Floyd, just relax. That's part of the issue, is he has not known who his probation officer is, Your Honor.
I mean, that's not the issue. He was with Mr. Farmer, and then Mr. Farmer got promoted. It ain't no big mystery. He was with Mr. Farmer. Mr. Farmer got promoted. He got assigned to somebody else. It's not a big mystery.
But he says that there was another officer before Mr. Farmer.
Well, let's not act like this is not a 2018 case.
Yes.
Okay, so it's a 2018 case, and there is a possibility that he has had more than one probation officer, because this is a 2018 case. So what we know is that his last probation officer got promoted to supervisor. That was Mr. Farmer. And then Mr. Farmer apparently must have assigned it to Miss Bryson. And so now it's Miss Bryson. What I'm struggling with at this particular moment is the fact that Mr. Floyd just seems like he can't sit up straight for court. That's what I'm struggling with at this moment. So it looks like he has proof of some things that may have gone to Mr. Farmer, but should have gone to Ms. Bryson because of the switch. I'm sure that as supervisor, Mr. Farmer is getting many more emails than he used to get. That's not an excuse for him not to have responded. So what we're going to do is Mr. Flanagan is going to submit those emails that you sent to me. Now, what you said, Ms. Stevenson, was that those are not all of the emails that he has, all of the receipts. So what I suggest that we just adjourn for a week. Ms. Bryson may have those things in her email. I don't know, but what I want to see is whether or not he has been submitting to the urinalysis, that he was submitting to the urinalysis at the time that Judge Baltimore originally signed for the probation violation order. Now he's almost up to his year, and they kept adjourning it, waiting on me to come. I guess nobody wanted to do it themselves. So I'll be satisfied and discharge him if those receipts are verified by Mr. Farmer or Ms. Bryson, and then we can go ahead and discharge him from probation. So we want to just adjourn it for a week? Because I don't know how long. He said he don't want to adjourn it for a week. Let's adjourn it till April.
That's actually, I think, what he was saying at this point. Just let it continue to the end because he kind of keeps coming back.
We have got to the point where literally
Okay,
nothing
well then,
happens.
I mean, well, that's stupid, but go ahead, let's do it. I mean, I don't even need to look at it. If he want to keep paying for drug tests through April, if he want to keep going to drug tests through April, then let's go. No, well, stop shaking your head and things and such then. And let's do the case. You know, I don't come on here to play games. Now, Judge Baltimore signed the order in my absence. I wasn't here. He didn't have the hearing. Otherwise, I wouldn't have. I said it. Y'all don't pay attention half sometime. Okay, I said it. Miss Bryson is not here. She's not here today.
Okay.
I don't know when she's coming back. I assume she might be on a week's vacation, as every person is entitled to who works a job. That's why I said adjourn it for 1 week.
Okay.
But we don't have
Just
to.
looking at how
Mr.
long is the
Flanagan, what's
testing
the
been going
final
on?
review date?
April 10th.
We can adjourn it to April 10th, so nobody has to keep coming back.
So could we look at it in a week, Judge? I mean, he has been, initially it was charged with the high BAC. So as a bond condition, he's been testing for over a year now. And I don't know that I've seen any violations.
This is what's bothering me, and I'm just going to let you know what's bothering me.
Yes, Your Honor.
When I said adjourn it to a week, nobody wanted to adjourn it to a week, right? When I was going to squeeze Mr. Floyd in, he was shaking his head no. And then you said, well, he just prefer to come in April. Now I said in April, now everybody want me to adjourn it for a week.
Could we have a week, please, Judge?
Let's just have a week. Let's come back next week and we'll see what Ms. Bryson has to say.
Okay.
Let's come back next Monday at the same time. Anything further?
Nothing on behalf of Mr. Floyd. Thank you.
did. He walking around. Okay, I'm ready on Wilson. This is case number 24-458-7401. The People versus Ike G. Wilson. Defendant is charged with assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Dawn McLeod appearing on behalf of the people.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Ike Wilson. Mr. Wilson, sir, please unmute and say your first, middle, and last names.
Good morning, I.G. Wilson.
Is your middle name G?
Yes.
I thought it was. No, I haven't seen Mr. Wilson before. That was somebody else with a middle initial.
You seen?
Oh, I have seen you. I knew. I felt like I remembered that. Okay. So today is the date set for pretrial conference. Ms. Stevenson.
Thank you, Your Honor. On behalf of Mr. Wilson, we would move for dismissal for the complainant's failure to appear.
Ms. McLeod.
Your Honor, the complaining witness is Aaron Amos. Our office contacted him on yesterday and gave him this information. I'm not sure why he's not here today, but we respectfully request, as this is the first pretrial, an opportunity to locate and notify Mr. Amos of his obligation to appear at these proceedings.
I mean, you sound like you know, notified him.
I didn't personally, but the note says that he was contacted and given the Zoom information, but I have no way of knowing why he has not checked into the meeting. He could be having technical difficulties. His name is Aaron Amos.
Mm-hmm.
Maybe there's a Zoom issue, technical difficulties.
Oh, you just gonna try to capitalize on the little slight Zoom issue. But if I were you, I would too. All right. I'm going to give a shorter adjournment because someone from your office spoke to the complainant.
That is correct.
And so that you don't have to locate them, but you do need to notify them of their obligation to appear before the court, or the case is going to be dismissed. I'm going to give a brief adjournment. Mr. Flanagan, Mr. Wilson, sir, do you work during these hours that you're coming to court here?
No.
Okay, so you don't, if I schedule it for next week, if I give the people a 1 week adjournment and schedule it for next week, Thursday, you would be able to attend?
Yes.
Okay, we're going to schedule it for next week, Thursday at 8:36. That's January the 16th. The complaining witness is required to appear. Failure of the witness to appear will most likely result in the matter being dismissed. I'm going to let in this unidentified device as we speak, but so that we can see if that's the person. And there's a George iPhone, but I don't know if that could be. I'm going to let both of these devices in, but if they're not the complainant, then we'll continue to that 1 week adjournment. Can the person identified as George iPhone please unmute and state your name?
George Cole.
All right, Mr. Cole, accept to join the breakout room and wait for a lawyer to come in to speak with you, sir.
Okay.
The person on the Samsung, can you unmute and state your name for the court?
Hi, Judge. My name is David DeLucia.
All right, Mr. DeLucia, please accept to join the breakout room and wait for a lawyer to come in to speak with you.
Okay.
All right, so Mr. Wilson, we're going to go ahead and continue. All right, this is case number 234416301, the People versus April Marie Hollins. Defendant is charged with 1 count of guns possessing while operating under the influence, and today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. May it please the court, Sophia Burton appearing on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. April Hollins. Ms. Hollins, ma'am, will you please say your first, middle, and last name?
Morning, April Marie Hollins.
Today is the day set for sentencing. On behalf of the people, are there any additions, deletions, or corrections to the pre-sentence report?
No, Your Honor.
On behalf of the defense, are there any additions, deletions, or corrections?
Your Honor, on behalf of Ms. Hollins, we've had the opportunity to review the pre-sentence investigation report. Judge, can you give me just a second? I'm having a problem with the iPad. On behalf of Ms. Hollins, Your Honor, we've had the opportunity to review the pre-sentence investigation report. We did find it to be factually correct. We have no additions or deletions at this time. Ms. Hollins does stand ready for sentencing.
On behalf of the people, anything as to sentencing?
Your Honor, the only concern the people have is that Ms. Hollis submitted to a analysis that was positive for drugs and alcohol, marijuana and alcohol. And so that is a concern considering this particular offense involved alcohol. Other than that, the probation department has recommended or submitted a fair recommendation, and we'd ask the court to adopt it.
Ms. Stevenson?
So, Your Honor, we want to, when I happened to be down at the probation department on the day that Ms. Hollins submitted, started her pre-sentence investigation, and she had to go do her urinalysis, and she was like, I didn't know I wasn't supposed to drink.
She's not being honest. She's not being honest.
So I looked at it again today, and I did advise her. I'm like, okay, I don't think it's true that you didn't know. I do think it's true that you forgot, because the order was given. I think we've been moving through this case for about a year. But I said that just to say, so that the court could know that Ms. Hollins was at least doing what she could do. She wanted me to come talk to you about it on the date that she went to the PSI interview. She just was trying to be upfront, and that's the reason I brought that to the court's attention. So Ms. Hollins, I did ask her about her source of income, and she said that she used to work as security, and she's trying to get back into that field at this time. If she can't get a job doing security, then she's trying to get a job doing retail work. But she gets food assistance. That's the only other source of income that she has. So at first I was looking at the community service recommendation from the probation department, and I thought that was a little bit excessive. I've changed my mind on that because, I think that the court did remind us that somebody in this courtroom mentioned that sometimes when people do community service, that turns into a job. And I think that would be very helpful for Ms. Hollins. So, the charge that she's here for is that she is in possession of a firearm under the influence. We don't have anything like that reoccurring since the time she started coming to court on this case. She's been here. She's been in communication with me. She doesn't have any prior criminal history. She's not trying to avoid any responsibility in this case. She knows that she's probably facing an advanced sanction because of consuming alcohol while she was on probation. But I do believe, despite that, Your Honor, that Ms. Hollins knows how to follow directions, and she intends to do that so that she can move past this. And so I'm asking the court to follow the probation department's sentencing recommendation. Place her on a term of probation with which I believe she will speedily comply. Let her move forward with her life, Your Honor.
All right, would she like to address the court?
Ms. Hollins?
Yes, ma'am. I do understand that of my sentencing today, and I am willing to fully cooperate with the courts and the probation to move on and succeed in a timely manner with my probation.
court is ready to impose sentence, I do so as follows. The probation department has recommended a term of probation of 12 months. I'm going to accept the recommendation for probation. However, the term of probation is 15 months with a final review date of January 14, 2026, an interim review date of February the 12th, 2025 at 10 o'clock a.m. The terms of the probation are as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state without consent of the court. You must make a truthful report to probation on a monthly basis and notify probation immediately of any change of address, phone number, or employment status. You will pay the following fines, costs, and fees. The mandatory cost of $210, $100 attorney's fee, $400 fine, $525 oversight fees. That is at a rate of $35 a month. For the halfway point, it would be $263. A $100 assessment fee. Court is not going to impose the urinalysis fees, but that's because she can test outside the court if she was testing outside the court. And then the total fines, costs, and fees, not including any urinalysis or classes, is $1,335. For the halfway point, it would be $1,073. Additionally, you shall not use or possess any illegal substances. You cannot use or possess any marijuana without a valid medical marijuana card. You cannot use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not consume alcohol in any form. You shall not drive without a valid driver's license. You shall not use or possess any handguns or firearms. You shall attend alcohol highway safety education level 1. You shall submit to random urinalysis twice per month. You shall attend outpatient treatment, Alcoholics Anonymous. You will complete 10 days of community service. That's equivalent to 80 hours of community service. You will attend the Victims Impact Panel, watch the consequences video. You will pay outstanding tickets that you owe with the 36th District Court. You will clear up all warrants that you have. You will attend the Choices program. Your first date, as I indicated, is February 12th, 2025 at 10 o'clock a.m. We will mail a copy of this order to the credit.
Nothing from the people.
Your Honor, we have heard the court's order, and absolutely Ms. Collins has indicated she intends to abide by the court order. I'm just with regard to the Alcohol Highway Safety Education Program, would the court be ordering that this was not a drinking and driving related offense?
She was had a gun while operating under influence. What are you saying?
I believe she was a
No, Your Honor.
Say that again.
I believe she was not operating a motor vehicle, Your Honor. There's no allegation that she was operating a motor vehicle.
Are we talking about, we're saying April Marie Hollins?
Yes, Your Honor, is charged with being in possession of her firearm while under the influence.
I apologize. Can somebody tell me what O stands for? What does O stands for? So, because I'm looking at the docket. So when I called the case, nobody corrected the case. Also on the, well, it is maybe correct. It says possession under the influence on the thing. So when I called the case, nobody corrected the case. It's OUI. So I don't know. I don't have the thing. So this says gun possessing OUI, operating under the influence. Isn't that what that stands for?
You actually won't believe what I got my Misfits Market box.
I'm not sure what it stands for, but she's charged with weapons, firearm possession under the influence.
Mr. Flanagan, so can we change it then?
Oh, yes, Your Honor, that's what it is in the system, weapons, firearms, possession under the influence.
So help me then. Why? Help me. That y'all not being honest. Help me with what is OUI on the docket then? Just tell me. I mean, somebody tell me. Mr. Flanagan, tell. What is gun possession OUI? What is that?
Operating under influence.
I know. So it's in wrong then. So somebody put it in wrong. It couldn't be correct. Somebody put it in wrong. It's in wrong because it's OUI. That means operating. The O stands for operating under the influence. But okay. So the O shouldn't be there. It should be just gun possession under the influence. Okay. So therefore, I will take away the victims impact panel and the consequences video and the driver's improvement program. All right. And the alcohol highway safety. See how 4 things come off because of that O? Okay. So that is okay. Let's correct it. Let's correct it. Let's correct it. All right. She has 3 warrants with the 36 district court, so she needs to clear those up right away. Oh, I did not order, but let me go back. So I am going to add, I didn't add it, the handgun intervention. I will order that as recommended by the probation. So we're removing alcohol highway safety. We're removing victims impact panel, the consequences video and driver's improvement. Those are removed from my order. And then we are adding handgun intervention. All right, anything further?
Nothing from the people.
So, Your Honor, Ms. Hollins does have a phone number for Judge Millhouse's courtroom, and she'll call them and get those warrants taken care of as soon as we get done in here today. Would the court consider outpatient treatment if there are any further positive tests rather than ordering that up front, Your Honor?
File your tax.
No.
Other than that, we have nothing further, Your Honor.
Okay. And let me just be clear as to why I'm not going to do that. I'm clear. I'm clear. When I speak, I'm clear. And yeah, when I speak, I'm clear. And so you can say she forgot and she can say she didn't know. But that also says to me then that she either didn't listen or didn't care. But I'm clear when I speak. So if it had been another judge that ordered that, maybe then I would say I can't guarantee that they told her. But I know that on at least 2 occasions, I said bond will continue, no drinking and no driving without a valid license. I say it. So we're going to go ahead and do outpatient treatment. And if the outpatient treatment people say that she doesn't need it, then I guess we'll go from there. But no, it's in the order.
Okay. Thank you, Your Honor.
All right, we're all set. Have a great day. Stay safe.
That is completely and absolutely unnecessary.
Why is that? Every day her doing harassment. They're doing things. What y'all waiting for them to kill me?
But let me make something clear to you today. Judge Lynisse Bryant is in charge of this courtroom. Judge Lynisse Bryant is going to give justice to whoever is in need of justice, but she's not going to prison.
Let me fix this. Having some difficulties. Hold on.
All right, I'm ready on, I need Ms. Moore to start her video. I need Ms. Moore to start her video.
You're being robbed and
I apologize, Your Honor. I didn't know how to do it.
Ma'am, yes, you did know how to start your video. Let's just move on. Let's move on. Just don't do that. This is case number 214548501, the People versus Regina Octavia Moore. Defendant is charged with assault or assault and battery, and today is the date set by Judge Baltimore for a probation violation hearing. Ms. Ritter, your appearance, please.
For the record, Your Honor, Christina Ritter on behalf of the people, the complaining witness.
What's going on in the courtroom right now?
Complaining witness, she's coming to the podium.
Okay. Ms. Ritter.
Thank you, Your Honor. The complaining witness is in person in the courtroom. Ms. Robinson, speaking to the podium, and state your full name, please.
Sandy Robinson.
All right, Ms. Moore, state your name. Unmute.
You say Regina Octavia Moore.
Ms. Moore, what's all that noise in your background?
Oh, it was the TV. I was in the breakout room. I'm sorry.
All right, today is a date set for a bond violation. Strike that, I keep saying bond. Probation violation hearing that was set by Judge Baltimore while I was off. And unfortunately, it was not properly set and the people were not even aware of the situation. Ms. Stevenson brought to the court's attention that Ms. Coulthurst was the attorney of record. Ms. Hauser, I need everyone to be stationary, seated.
I have kids here at home, so.
Okay, well, take care of your kids and come back to court when you finish taking care of your kids. You have a great day and you stay safe.
I'm not saying.
All right. That Ms. Coulthurst was the attorney that represented Ms. Moore previously. The court did reach out to the Michigan Indigent Defense Council and asked for Ms. Coulthurst to be appointed to represent Ms. Moore during her probation. And I believe that request was granted. Ms. Coulthurst has indicated that she's unavailable this morning.
but is able to log into Zoom this afternoon. So I believe I'm going to just have everyone log into Zoom this afternoon and then set the matter, if necessary, for a hearing after the people have had an opportunity to review the evidence. Ms. Ritter?
Judge, thank you. So, Your Honor, the court is correct. The people have not had an opportunity to review the evidence relating to this hearing. I did have an opportunity to speak with Ms. Robinson during a brief break from the court. Ms. Robinson being, I guess, agitated with how the people wanted to proceed as far as holding this probation violation hearing and giving the people an opportunity to give a sound argument and decision in making with this process. She wasn't satisfied with what the people were trying to tell her. So just so the court is clear, and just so Ms. Robinson is clear, it is up to the people. From my understanding, it's up to the people as to how they're going to proceed after viewing the evidence, whether they're going to proceed or not to a probation hearing. And from my understanding, Ms. Robinson has been in contact with Ms. Lurst. So Ms. Robinson is, I guess, has confidence in the probation as to handling this hearing opposed to the people.
Ms. Lurst is not an attorney today. She wasn't one yesterday, and she won't be one tomorrow. I could care less about how Ms. Lurst wants to proceed. So number one, as I indicated in the beginning, the matter was set inappropriately on the court's docket. It should have never been set on the court's docket without the prosecutor having the opportunity to review the evidence. I'm almost, okay, what word am I going to use? Okay, I don't know what Ms. Ritter means when she says that what's your witness's name?
Ms. Robinson.
That Ms. Robinson was irritated with how she want to proceed, but on every day that we live and breathe and court operates, it is the prosecutor's case. It is the people's case. And what we won't do, what I won't do, is have anybody dictate to me how to run my courtroom, except the Supreme Court and the legislature. Court rules and case law. That's what run my courtroom. Court rules and case law. Okay, so, and that I'm a little, I don't know. Okay, perhaps there was some type of misunderstanding as to who Ms. Lurst is. Ms. Lurst is a probation officer who shouldn't even be talking to the complaining witness. Let me be clear. Let me be clear. Ms. Lurst is a probation officer who should be talking to the probationer. She is overseeing the probationer. She has no business, none. Let me make the record clear. She has no business communicating on this level with the complaining witness. Her responsibility and obligation is to the probationer. The only thing Ms. Lurst is supposed to do is make the court aware of an allegation. She should not meet with the complaining witness. She should not have received a video from the complaining witness. She should have brought it to the court's attention. The video should have been sent to the prosecutor. And then the court would make a determination as to whether or not a probation violation hearing was necessary. So I don't know what you said to Ms. Ritter on the telephone. I don't know.
We're Phoenix Energy.
But Ms. Ritter is the lawyer. She's the attorney. Ms. Lurst is the probation officer. Probation officer for Ms. Moore. Ms. Lurst is the probation officer for Ms. Moore. Ms. Lurst is the probation officer for Ms. Moore. Okay. Having said that, we are going to log in for this case at 1:30. The people are going to get a copy of the video from Ms. Lurst, who apparently is the only person who can see the video. That's inappropriate. It's inappropriate on every level. It's inappropriate. It's inappropriate for the video to be on her personal device. It's inappropriate. It's inappropriate for the prosecutor to not be able to view the video. It's inappropriate. It's inappropriate for the defense attorney to not be able to view the video. It's inappropriate. It's inappropriate. It's not appropriate. Okay, so we're going to log in this afternoon. If she chooses, I suppose, the witness will send the video to the prosecutor, which is what Ms. Lurst should have done. Upon receipt of the video, she should have forwarded that video to the appropriate people. Okay. The only thing, okay, I think we all know that I feel like it was inappropriate. Okay. So, Ms. Ritter, if you are able to view the video by this afternoon to determine and let the court know if in fact we do need a probation violation hearing, or then we will proceed in that manner. If you're not able to view the video by this afternoon, then I suppose I'm not going to set a bond violation hearing unless I know, I keep saying bond, and I'm sorry, a probation violation hearing unless there's let me see what the standard is for the probation violation. It's not probable cause. It's what's the one down below that?
Clear and convincing evidence.
Preponderance
Say that again, Ms. Stevenson. I'm sorry.
of the evidence.
Oh, preponderance. That's what yes. Preponderance of the evidence that there's a need for a bond violation hearing. Ms. Ritter, were you even able to speak with the witness regarding what the allegation is?
I was there, so I was able to get an understanding of what the allegations are, and it is no contact, indirectly and directly.
Okay. All right, well, we will be back at 1:30 on Zoom. Ms. Coulthurst has been appointed to represent Ms. Moore. The witness does not have to come in person. There will not be a hearing today. However, if she wants to come in person, she can. But there will not be a hearing today, and we're going to pick a date for the hearing if that's necessary. So I need Ms. Coulthurst because I need her calendar. I need to know her schedule. Okay. Anything further?
Nothing further for the record, Judge, just that I will contact Ms. Robinson after the docket is complete to see if there's a way that I can get that video to review it before the 1:30 adjournment.
There has to be a way. Ms. Lurst has it. So there absolutely has to be a way. Ms. Lurst has the video. Ms. Lurst, the probation officer, who can't share the video for some reason with anybody else. So she has it. So there has to be a way. All right. Anything? What's going on? Why is the officer talking to the witness?
Your Honor, I'm telling her to take her arms down and she's refusing to do so. That's why I was talking.
Cause it's time to go. I've been trying to.
Man, who you talking to? Who you talking to? Who are you talking to? Who you talking to? Who you talking to? Who you talking to? are you talking about?
Her and her daughter every day.
Officer, you're gonna take her in the back.
Right.
She's gonna stop.
You know, I mean, cause it's
You're
gotta
gonna
go.
stop. You're gonna stop. You're going to stop. You are going to stop. You're going to stop. Ma'am, you're gonna stop. Stop it. Stop it. No, stop it. Stop it. Ma'am, stop it. That is completely and absolutely unnecessary.
Why is that? Every day her and her daughter harass me. They doing things. What y'all waiting for them to kill me? Every day.
Let me tell you what I'm getting ready to do. I'm getting ready to get in my car and I'm getting ready to come down to the court. You're gonna put the, we're not having no hearing and it ain't gonna turn out for you. I'm getting ready to appoint, I'm getting ready to appoint you counsel, ma'am. I'm getting ready to appoint you counsel. That's what's getting ready to happen. So you think it's good for me to come down to my car? You think that's good for you? Let me be clear.
Maybe somebody will hear me.
It's not clear. It's not clear. Let me tell you this. You're gonna hear me. You're gonna hear me. You're rude. You're being disrespectful. You're being disrespectful to this process. You keep rolling your eyes at me. You keep tooting up your mouth at me. You keep over talking me. I have asked you to stop. I have raised my voice. I have lowered my voice. You continue to be rude. You continue to not let the process go. You continue. And then while you're continuing to behave in this manner, you want the prosecutor to present evidence to me that you're the one being harassed. Now, what I'm saying to you is that you are going to stop. If you continue, I am going to hold you in contempt of court. And that is not a good thing. If I get in my car to drive downtown, there is a 90% chance. If I get into my car and drive downtown to address you, there is a 90% chance that you are going to go to jail today. So you're going to stop being rude to me. You're going to stop. You're going to stop, because what you must think is that this is a free-for-all and you can talk when you want to talk. Well, ma'am, that's not how court works, and you're going to stop. You're going to stop. There's not going to be a day. There is not going to be a day when I'm not going to be in charge of this courtroom. There's not going to be a day, ma'am. So I need you to stop. Now, I am trying to address your issue. You are making it 1,000 times difficult for me to address your issue. What you're going to know is that this is a misdemeanor. This is a misdemeanor. So you said, what we going to do? We're going to wait for her to kill you. This is a misdemeanor. Misdemeanor. If you have an issue that you think is bigger than this, then you need to go talk to Kim Worthy. Look like you're in the wrong place. You need to go across the street and yell at Kim Worthy, but you're not going to keep yelling at me, because when you yell at me, you're going to go to jail. And then you can yell at them from over there in the jail. But what you're not going to do is disrespect and yell at me. That's not what you're going to do. Every day I come to work and put on this black world, I'm in charge of this courtroom. Every day. Every day. And you're not going to disrespect me. Now, this morning, you have disrespected me. This morning, you have disrespected this process. This morning, you have been very disrespectful. This morning, you have yelled at me and talked over me. I don't know where your emotions lie. And I don't know what Ms. Lurse told you. But let me make something clear to you today. Judge Lynisse Bryant is in charge of this courtroom. Judge Lynisse Bryant is going to give justice to whoever is in need of justice, but she's not going to prison. It's a misdemeanor. It's a misdemeanor. So you need to talk to somebody else who's able to give you the relief that you need. But you're gonna stop yelling at me. You're gonna stop yelling at me. And know this, the officer is in charge of that courtroom. The next time he gives you a directive and you don't follow it, I'm gonna hold you in contempt of court. You're not gonna argue with my officer. He is there for the security of that courtroom. He is there to make sure that courtroom decorum is followed. That is why he is there. The fact that you would argue with him speaks volumes about you, number one, and number two, it's disrespectful to this court process and to these proceedings. Now, I understand emotions get high. I understand that. I understand that you're the one living your situation, but you're not gonna come here and yell at me. You're not gonna come here and disrespect me because I've done nothing to you. Nothing. I don't even know you. I've never met you. I've done nothing to you. Neither has my court officer. We are here to do a job. We are here to conduct business. We are here to listen to all sides, not just yours. And you yelling at me, trying to tell me your side is going to accomplish zero, nothing. Absolutely and positively nothing. If you need a PPO, go get one. We don't give them out in this courtroom. If you need some larger charges, go talk to the prosecutor's office. We don't do that here. But what we do here is demand courtroom decorum. What we do here are handle the misdemeanor cases that appear before this court. The cases that are punishable by 93 days in the Wayne County Jail, maximum. This case, maximum. So don't ever do that again, ma'am. Don't ever do that again. Don't ever do that again. Don't ever do that again. All right. As I said before, the witness started yelling at me and over talking me and all of that. We're gonna come back at 1:30. And Ms. Moore's attorney will be present. Ms. Ritter will do what she always does and determine if whatever the evidence is, if she is going to proceed with the probation violation request. And then Ms. Lurst, who's not an attorney, and who's not going to be presenting any evidence to this court, is going to, as much as we can, try to forward the video to the parties, or Ms. Ritter, if she's gonna give you the video, she can give it to you. I don't know. I don't know. I don't know. Okay. Is there anything further for the court?
Not from the people, Judge. Thank you.
All right, Ms. Moore, Ms. Colthurst has been appointed to handle the probation matters, and so log back in at 1:30.
Yes, Your Honor.
All right, then we're all set, and I'll see everyone this afternoon.
Thank you, Your Honor.
Thank you, Your Honor.
Respectful to me. Everybody's gonna be respectful to me, or it's not gonna be a good day. I'm ready on Hauser, who's also going to be respectful to me. Okay, now, Ms. Hauser wasn't in the courtroom when I just gave this long speech about being respectful to me, but this 2024, let me tell you all something, a news flash. I refuse to be disrespected in 2024 on my job. You're not going to talk to me in a random and unprofessional and disrespectful way without consequences, I refuse. I am being paid to do a job, and I'm going to do that job with the respect of the people, the public, the lawyers, and everybody else, and I'm going to give it. You're going to stop walking around. The fact that you have children at home is your business. But we got a court hearing this morning. And if this was pre-COVID, I don't know where your children would be, but they wouldn't be interfering with this court hearing. So don't talk to me like that again. And the next time, if you have to come back for a court hearing, then you need to make accommodations for the things that's going on in your house. Because you wouldn't appreciate it if I had to keep getting up out of my chair, going to take care of some kids, a dog, the this and the that.
John.
So we're not going to do that.
Right
this
here.
is case number.
Imagine being able to build an app with your name on it.
Let me skip this ad.
Two 450-9601, the people of the state of Michigan versus Ariel Hauser. The defendant is charged with 1 count of assault or assault and battery. And today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Ariel Hauser. Ms. Hauser, ma'am, please unmute and say your full name.
Ariel Hauser.
Today is the date set for pretrial conference. How are we proceeding?
Thank you, Your Honor. On behalf of Ms. Hauser, we would move for dismissal for the complaining witness's failure to appear.
Ms. Ritter?
Judges, at least the second scheduling of the pretrial conference, the court did require the complaining witness, Ms. Daisha Wary, to be present. I'll see the complaining witness by that name in the waiting room, and the people don't have an explanation as to why the complaining witness is not present for at least the second scheduling of the pretrial conference. At this time, Your Honor, the people will not be able to proceed based on the complaining witness's failure to appear for at least the second scheduling of the pretrial conference.
Today is the date set for pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for that failure. They are unable to proceed at this time. The court is going to grant defense counsel's motion, and the matter is dismissed without prejudice. Ms. Hauser, we will mail you a copy of the order of dismissal for your records, ma'am. Have a great day. Stay safe.
Thank you.
So while I'm fixing this little discrepancy that I just come up, just remember, everybody, judges have the right to demand respect. It's like she said, she's doing a job. She's trying to do her job. All these judges are trying to do their job. And when you come to court and you're being disrespectful, yeah. Just trying to make sure that it does not show up on here again. Nope. All right. Let's get this started again. These must be old cases. Yeah, when you when you're in court, you're supposed to show some kind of decorum, like she said. You're also supposed to have respect for that judge. If you come in there mouthing off to a judge, yeah, you're gonna get fined with contempt of court. A lot of these judges don't play that. If you don't show up for court, yeah, you're gonna get a bench warrant. There we go. So, you know, you need to show respect for the judges. So let's keep going here. Whoops.
The order to be what I said on the record, because we can get the transcript. So if I'm
Your
amending
Honor,
the order
Your
to
Honor, that's
reflect
true.
what I
So we
said
can get
on
the
the
transcript,
record,
but you did, an order was filed on
Mr.
the file.
Gregory, do not ever interrupt me. Anything.
Understood, Your Honor, but everything that is an amendment on the record should be discussed.
This is going south. It's really going south at this moment. It's really going south. I'm going to say this for the last time. That's my order. Good morning, Ms. Langowski. I'm going to send you to a breakout. Whoops. I'm going to send you to the breakout room. Wait for the lawyers to come in to talk with you. Please join breakout room number 9. I'm ready on Jackson. All this time, does Ms. Jackson have on a white t-shirt? I'm gonna put Ms. Jackson back. Oh, this is Ms. Langowski. I said Jackson. That's Ms. Langowski. I'm gonna put Ms. Langowski back in the breakout room.
Okay.
And then she's gonna change her shirt.
I have to change my shirt?
I'm ready on Jackson.
Yes.
Ms. Jackson, start your video. I need her order because this isn't, hold on. Oh, here it is. She has paid her fines, costs, and fees. She has completed her anger management. It doesn't say anything about her mental health treatment. Can you call Miss Bumpus and ask her if she has any verification of the mental health treatment? Mr. Gregory, what's going on with the mental health treatment?
Your Honor, the report that I got indicated that she was completed with her, she had no remaining conditions.
That's what it said, but the completed conditions doesn't say anything about mental health treatment. Completed condition says she's paid her balance, she's done her anger management, and doesn't say anything about mental health treatment. Her order indicated that she was supposed to continue with her mental health treatment. So has she continued with mental health treatment?
Your Honor, we may have to go back into a breakout room.
Am I allowed to speak?
You may.
I am in therapy. I still do therapy. That was one of the things why I was in therapy when I got sent the thing that I was supposed to do. But yes, I am still in therapy.
And did you provide proof of the therapy to your probation officer?
No, I didn't know I was supposed to. I spoke with her a few days ago and she said everything was in, so.
Okay, well, let's see. I don't know why she would say that without giving me an update on the therapy. Okay, Mr. Flanagan, do we have an update on Langowski?
Oh, yes, Your Honor. I sent you a chat.
Oh, okay, thank you. It's not true. It's not true. I'm looking at the order. I'm looking at the order. Who said that? I'm looking. Who?
Ms. Bumpus.
So you telling me that Brittany Langowski did not get ordered to pay $810. And then her order does not say, shall not violate any laws, must report monthly, must notify probation officer of change of address and work status, shall not use or possess any illegal substances, shall not use or possess any marijuana without a valid medical marijuana card, shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor, shall not drive without a valid driver's license, 4 weeks of anger management, must continue with mental health treatment, maintain no contact with complaining witness Crystal Harris. You're saying that's not her order?
Everything is listed except for the continue with mental health treatment.
I have this order right here in front of me. So what are you saying? It's two orders?
I'm looking at the order of delayed sentence that's in the file.
Okay, Jesus. All right. I want proof of her mental health treatment before I discharge her from probation. I just can't imagine why that wasn't on there.
Your Honor, respectfully, Ms. Langowski has followed the court orders and has continued.
Mr. Gregory, I want proof of her mental health treatment before I discharge her from probation. She has indicated that she has been in treatment even before she was sentenced. Getting proof of that treatment is immediate and easy.
I understand, Your Honor.
I'm not discharging her from probation until I get proof that she is in the mental health treatment. Anything further? Because I'm going to give her a week to get us that proof.
Yes, I just want the record to reflect that she did follow
the record reflects
the court orders.
Gregory, I'm not going to argue.
I understand, Your Honor, but I would listen, Your Honor. I would like to make this
Mr. Gregory, I want proof of her mental health treatment. So if that is going to reflect, I'm amending the order to be what I said on the record, because we can get the transcript. So if I'm amending the order
that's true.
What I said on the
record, but you did an order was filed on the file.
Mr. Gregory, do not ever interrupt me. If it's an issue of me amending the order to reflect what I said on the record, then that's what I'm doing. I'm amending the order to reflect what I said on the record, which is continue in mental health treatment. And since Ms. Langowski has said today that she has continued in the mental health treatment, then it's no issue. I don't even know why we're discussing it. So she's going to get the proof that she has continued in the mental health treatment, and then I'm going to discharge her from probation.
Understood, Your Honor, but everything that is an amendment on the record should be discussed.
This is going south. It's really going south at this moment. It's really going south. I'm going to say this for the last time. That's my order. That's my order. I'm going to say that for the last time. That's my order. Ms. Langowski, how long is it going to take you to get proof of the mental health treatment?
I can drive up there right now and get the paper. I go down the street to therapy. So do I just upload it somewhere or send it somewhere?
Yes, you're going to send it to, you can send it to Ms. Bumpus, or you can send it to Mr. Flanagan.
And then I
Your
have
Honor,
to come
if
back.
you can get that paperwork in today, would that be able to?
Absolutely. Absolutely. Do you need Mr. Flanagan's email address? They may not be able to give it to you today. But if they give it to you today, you can send it today. And if not,
they gave me one. My lawyer was Scott Wangburn, but he's not my lawyer anymore. So I'm assuming he didn't upload it, but they gave me a paper back when I was supposed to do all this and I thought it was all uploaded, but they'll literally give me a sheet of paper today saying that I'm in treatment.
Okay, well then, let me give you the email address to send it to.
Okay, okay. Okay, I'm ready.
At 36th districtcourt.org. That's the numbers, 36.
Okay.
If you
Okay.
email him that today, I will dismiss the matter with prejudice. I will remove the conviction from your record, and I will close the case with improvement.
Okay, thank you.
If you cannot get it to him today, call the courtroom and let them know when they say they can get it to you, okay? If for some reason they can't. So do you need the courtroom phone number?
Yeah, I was supposed to call Ms. Bumpus after court today too. So I can send it to both just to make sure it gets there.
Okay, that sounds great.
Okay, and what's the court number?
965-2295.
Okay, thank you.
All right, you're welcome. Have a great day. Stay safe.
You too.
Thank you. Mr. Flanagan, send me that order because I'm trying to figure out why you have a different order than I do.
Okay.
Thank you. Okay, let's see.
Let me see if I can find that one with Judge Middleton. That woman defying court order. Because Judge Middleton told her, do not show up for court under the influence. And this woman kept doing it. And she had to face the consequences of her actions. I think this is the one. This is one of them. Whoops.
May 26th, which resulted in this conviction, May 26th of 24. She was in a crash and her blood alcohol was 0.294.
Oh.
She got arrested again on August 7th for drunk driving and file number 241471SD. Her blood alcohol at that time.
Basically, it's just there was a case in Judge Middleton's court where Judge Middleton told her, this woman, and I think it's the same one, don't come to my court under the influence. Told her the first time. Second time she came into Judge Middleton's court, she was under the influence. He told her, don't come to to my court under the influence. I'm going to lock your ass up. Well, lock her out. She came to the court before him the third time, and he locked her up for 93 days. This might be the case. But let's go. I'm going to fix this. Go back to Judge Bryant. Hold on. Judge Bryant. All right, so let's go back to Judge Bryant.
Lawyer will speak to you, okay?
Okay, but I don't understand the charges that y'all have.
Ma'am, listen to what I'm saying. I am getting you an attorney.
Okay.
Your attorney will speak to you. And then you can ask your attorney however many questions you want to ask your attorney. But I am not your attorney, and I'm not going to explain it to you. You have been charged with assault and battery. 2 counts. That's easy. That's simple. That's it. Anything else? And also, I'm confused by why y'all have a name on the screen that's not on my docket. The only name I want to see on a person is the name that's on my docket, so you all need to change her name.
Is this for Thomas?
Okay, you may.
Your Honor, when we had Onaya Thomas on there, actually Latrice Thomas Cook and Latrice Thomas Pearson. I made a mistake and put Cook there. It's Latrice Thomas Pearson and Onaya Thomas Cook. They were on the same camera. Ms. Stevenson asked me to.
I see what you mean. Oh, because that person is on my docket.
Correct.
I see.
And they both been there, but we need to get appointed counsel for Miss Latrice Thomas. And we were going to represent Onaya Thomas Cook.
Well, they can't be on the same camera. What? They only have one device?
Yes, Your Honor.
Oh no, somebody gonna have to get it. They're gonna have to come in person. One of them will have to come in person. They can't be on the same device.
I can get another device if that's okay.
No, we're gonna go. We're gonna go ahead today. I need the complainants to turn on their videos, and then.
She got her phone.
Like I only want. Let me help y'all with this. We're in court, okay, and then I gave my instructions. Okay, so I'm gonna do. So who's on the camera now? This is Miss Thomas Cook.
Yeah.
Correct, Your Honor.
All right, so I'm gonna call the cases separately, and I will allow But Miss Thomas Cook, the angle of the camera, I don't know what's going on, but I need you to kind of be sitting up like this right here. And I need you. Can y'all stop? Just listen. Listen to my instructions, because how can you know that you are if I'm giving instructions? I haven't even finished giving the instructions. And I need you to be stationary, stabilize your device, and don't have it so close to your face. That's what I need. All right. And then I don't know what Miss Williams is doing, but I need you to stop doing it with your fingers. Whatever it is you're doing, Miss Williams, I need you to stop. Okay. So I'm going to call Thomas Cook first then. All right, this is case number 234476601, the people of the state of Michigan versus Onaya Thomas Cook. The defendant is charged with 2 counts of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please. Bond will continue with no contact with the complaining witness. Anything further with respect to Ms. Thomas Cook?
Nothing.
I'm sorry, Your Honor, not from the people, Judge. Thank you.
Nothing further, Your Honor. Thank you.
All right, Ms. Thomas Cook, you're all set. You have a great day. Stay safe. Can Ms. Thomas please come to the screen? Can we rename Ms. Thomas so I don't call her the wrong name? All right, this is case number 234476602. People of the state of Michigan versus Latrice Kawante Thomas. Defendant is charged with 2 counts of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I also have the complaining witness present via Zoom. Ms. Hall, can you start by saying your name for the record, please?
Brandis Hall. Brandis Hall.
Thank you. And Ms. Williams, can you unmute and state your name for the record?
We got a video.
Dina Williams.
And yes, Your Honor, Brandon Bird on behalf of Latrice Thomas for the purpose of this pretrial.
Okay, Ms. Thomas.
Ms. Thomas. Sorry, Your Honor.
Ma'am, state your name.
My name is Latrice Thomas Pearson.
What's your middle name, ma'am?
Quantel.
Thank you. Today is the date set for a pretrial conference. How are we proceeding, Mr. Bird?
Your Honor, respectfully, we have to ask to get appointed counsel for Ms. Thomas due to a conflict.
The court is going to continue a not guilty plea on behalf of Ms. Thomas. I'm going to set the matter for final pretrial conference October the 3rd, 2023 at 9:01. Mr. Flanagan, please submit a request to Ms. Carter for the appointment of counsel for Ms. Thomas. Did you all speak to Ms. Thomas in the breakout room?
We spoke to both of them about what was going on, but we did let Ms. Thomas know that she was going to have to get another appointed counsel due to the fact that we're
Thomas's contact information.
We do have Ms. Thomas's contact information, Your Honor.
All right. So please pass the contact information on to Mr. Flanagan so that he can pass that on to Ruth Carter. Ms. Thomas, what is it?
I'm still trying to figure out who do we give this. We have a video of the whole thing. So.
Ma'am, I don't care. I'm appointing you counsel. I'm appointing you an attorney. And we're not speaking in we's. I'm only talking about you. That's why I'm appointing you counsel. So what I'm saying to you is worry about yourself.
Okay, and my
counsel and Ms. Thomas Cook has her counsel, and they will speak to her, and your lawyer will speak to you. Okay?
Okay, but I don't understand the charges that y'all have.
Ma'am, listen to what I'm saying. I am getting you an attorney.
Okay.
Your attorney will speak to you. And then you can ask your attorney however many questions you want to ask your attorney. But I am not your attorney, and I'm not going to explain it to you. You have been charged with assault and battery. 2 counts. That's easy. That's simple. That's it. Anything else that you need to know, I am appointing you a lawyer. The lawyer is going to call you, reach out to you, show up in court for you. Okay?
Okay.
All right. Mr. Flanagan, you're going to get her contact information from Mr. Byrd, and we're going to pass that contact information on to the Michigan Indigent Defense Council so that they can appoint a lawyer for Ms. Thomas. Anything further with respect to this matter?
Not from the people, Judge. Thank you.
Nothing further, Your Honor. Thank you.
All right, then we're all set until October the 3rd at 9:00 a.m. on Zoom. Ms. Williams and Ms. Hall, you both have appeared today. Therefore, your appearance is not required on October 3rd. However, as the complaining witnesses in this matter, you may show up for every court hearing. You're not required to, but you may do so should you choose to. If you do not appear, then you should contact the prosecutor's office or the victim's advocate's office to find out when the next court date is and whether your appearance is required. We are all set. Everyone have a great day and stay safe.
Thank you, Your Honor.
You're welcome.
This video and all comments.
Well, let me say this. 36th District Court is open. We're open for business.
Okay.
What I'm not going to do is wait for you to walk from your house to your porch, from the porch to the yard, I'm not going to do that, Nick. I am not going to do that. Now you need to be ready for court. I'm certain that I said earlier, remain stationary.
Yes, ma'am, you did.
Upright. I know I did. Please don't interrupt me. I said remain stationary. Seated in an upright position, ready to attend court. You did not remain stationary.
This video is educational. It is not legal advice. This video is provided purely for educational discussion of courtroom procedure. All comments are my opinion. All persons are presumed innocent unless proven guilty in a court of law.
We're all set with Mr. Hood. Have a great day, sir. Stay safe.
All right, you too.
All right, thank you. I'm ready on Kennedy. This is case number. Ms. Kennedy, I need you to be still. Mr. Kennedy, I need you to be still. This is case number. These are case numbers. The defendant is charged with 1 count of assault aggravated. Today is the date set for final pretrial conferences as to each matter. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Your Honor, Austin Gregory, P85193 on behalf of Mr. Kennedy, who's present by Zoom. Mr. Kennedy, please unmute and state your full name for the record. You have to unmute first, Mr. Kennedy.
You have to be still too. This is too much. This is too much, Mr. Kennedy. It's a table over there. Can you go sit down at that table? This is too much.
Bust his balls, Judge Bryant. Bust his balls.
Oh, blessed assurance. Oh, did I say that? Oh, I said that. Oh, okay.
Right there with that microphone. You should be able to hear it. Hello? Can you hear me?
Yes, Mr. Kennedy, please state your name for the record.
Thank you. My name is Marvin Kennedy.
I've been wondering, can you hear me? Because if you can
Yes,
hear
ma'am.
me, well, you sure not. You're certainly not following my instructions.
Ma'am, respectfully, Your Honor, I
No,
could
it's
not hear
no,
you.
it's no respectfully. No. Respectfully, Mr. Kennedy. Look like you need to come to court in person. Now, I got a feeling we might have gone through the same thing the last time you came. Well, let me
No,
say
ma'am.
this. 36th District Court is open. We're open for business.
Okay.
What I'm not going to do is wait for you to walk from your house to your porch, from the porch to the yard, I'm not going to do that, Nick. I am not going to do that. Now you need to be ready for court. I'm certain that I said earlier, remain stationary.
Yes, ma'am, you did.
Upright. I know I did. Please don't interrupt me. I said remain stationary. Seated in an upright position, ready to attend court. You did not remain stationary. You were not seated in an upright position and you were not ready to attend court. I'm not going to do this with you again. Next time I'm going to delete you from the screen and a warrant is going to go out for your arrest. You need to come to court in person. Ms. Gregory, how are we proceeding today with these 3 cases? All of them are scheduled for final pretrial conference.
Your Honor, we are asking that these not guilty plea be continued and that they be set on track for a jury trial.
Well, okay, and I'm gonna give him a jury trial too, because this right here is too much. This is too much. And he has 3 cases and we're going to trial. And we're going to trial this year. Why do I have pork minor? When is Judge Garrett coming back? Let me call. Y'all don't know. I wasn't asking y'all. Don't worry about that. I'm gonna find out because I'm gonna take one of his jury trial dates. Hold on. Because this right here is too much to take into the new year.
We're sorry. All of our representatives are still assisting other customers. Please remain on the line as we value your call.
All right, September 27th. When is the last time the people's witnesses came?
Judge, it is the same complaint witness for all three cases, and she appeared on May 26, 2023.
Great. Call her. Tell her September 27th. She on queue for three trials. May. I mean, what girl? I went back to May. Because that's what you said she came. September 27th. And then let me be clear. If there is an offer on the table from the people, it expires on August the 30th, because then they're gonna bring in the juror. They're gonna summons those jurors for me for that special day. And after that, it's no offer after the final pretrial conference, August 30th at 9:10, and jury trial September 27th. Anything further?
No, thank you, Judge.
Nothing further, Your Honor.
All right, then, Mr. Kennedy, you're all set. And on August the 30th, the hearing is in person. So put that at 9:12. That's in person. It's too much. It's too much. All right, anything further?
Nothing further, Your Honor.
I'm sorry, I didn't know if I heard Ms. Ritter. That's why I said that. I'm sorry.
Oh, I'm sorry, Judge. Nothing further from the people.
Well, that's going to be it for today, ladies and gentlemen. I hope that you're really enjoying this content. If you are enjoying this content and you're not a subscriber to this channel, please do me a big, huge favor and subscribe to this channel and help this channel grow. I broadcast every day at 3:00 p.m. Central Time, 4:00 Eastern Time, with different judges, real court cases, and the real consequences of the crimes that the people commit. Like the video says, everybody is innocent until proven guilty in a court of law. So that's it for today, ladies and gentlemen. I will see you guys tomorrow. Ta-ta and ciao, ciao, and have a good evening.